we are all working in a very messy and complex regulatory framework. So this is a case that is dealing with the consequences of unfair dismissal. That is a different legal framework from your workers' compensation regime, the new powers under the Sex Discrimination Act, the powers of the Australian Human Rights Commission to investigate, and it's different again from potential proceedings under work health and safety legislation.
The concept of psychosocial risk is far from new, but the dialogue and industry discussion about the topic has elevated since regulatory changes were announced in 2023 and 2024. Psychosocial risk is now the focus of many conversations in the corporate world, from boardrooms to executive teams, and of course through to the practitioners on the ground, trying to join the dots to have meaningful impact. I'm Kate Connors. I'm a master's qualified psychologist, and my professional purpose is to help people and workplaces be at their best.
And I'm Greg Smith. I'm a lawyer who's spent more than 30 years practicing in the areas of employment law and workplace health and safety. I'm also the author of several books, including Paper Safe and the recently published Proving Safety.
And you are listening to Judgmental, when a psychologist and a lawyer walk into a barside chat about psychosocial risk. A big thanks to our sponsor, EML. EML are Australia's largest personal injury claims provider, providing claims management services to workers' compensation, life insurance and CTP markets, with the purpose of helping people get their lives back. We have another jam-packed episode today, so grab a drink and sit back for another discussion at the bar. Good morning, everybody. Thank you so much it's actually now afternoon for those of us in the east, but good morning to people in the west. My name is Kate Connors. We have Greg Smith with us today, who is the star of the discussion. And I just wanted to kick off by saying that and acknowledging that today I'm on the lands of the Wurundjeri people of the Kulin Nation. Greg is on the lands of the Binjara people of the Noongar Nation. And we both would want to just take a moment to pay our respects to those lands, the elders, past, present and emerging.
So I'm going to dive in, Kate, if that's all right, and get the conversation started.
Yeah.
Okay, to some extent the case is not particularly unusual, but it is a prompt to the discussion and it raises a couple of issues for us. So the case we're talking about is the Elijah and Vision Australia case, which originally kicked off in the Victorian Supreme Court, and then it went on appeal, and now leave has been granted to appeal to the High Court. And the case fundamentally is about a person's entitlement to recover damages for psychosocial harm caused by the termination of employment process. And I think one of the interesting things about this case, and when we look at what the High Court is probably going to consider, because we don't have access to the High Court application, we just generally from some of the hearings we had a sense of what it will be about, is that people, and I had this conversation in an executive briefing the other day where one of the senior managers in the organisation said, well, Greg, given that this psychosocial stuff is all new, are the courts going to take a lenient approach as we work our way through it? And that was a conversation that really caught me by surprise because psychosocial hazard risk wellbeing in the workplace is not new. And in fact, one of the cases that the court is being asked to look at is the Addis and Gramophone Company case, which is, if you're interested, I can provide you with a copy, but that's a 1909 decision looking at psychosocial harm from termination of employment. Courts and tribunals have been dealing with this issue literally for over 100 years now. It is not new. And the fact that the Australian regulators decided in their wisdom or lack thereof to put psychosocial regulations into the work health and safety regs is neither here nor there to the legal principles. I mean, those regs create a spectacularly unhelpful checklist that is going to do nothing to improve the psychosocial health of people in the workplace. So let's put that to one side for the time being. And for what it's worth, even from a work health and safety perspective, leave aside the compensation ideas, for at least 10 or 15 years, most regulators in Australia have recognised that psychosocial health is part of their remit under safety and health legislation. They've just done nothing about it. And there are prosecutions going back decades of organisations and individuals who have been prosecuted under health and safety legislation for things like bullying and harassment. Most famously probably is the Victorian Cafe Vamp decision, where a young waitress committed suicide as a result of persistent bullying. So we're not talking about anything new in a lot of senses. But the High Court has now got the opportunity to revisit this very important, in my view, very important aspect of performance management. So just to explain, and then I'll throw to Kate to talk about the management of the sort of risks that came up. Fundamentally, this case arose when the employee had their employment terminated and their employment was unfair. So there's no question that the employment was unfair, and there's also no dispute that the workers suffered psychosocial harm as a result of the termination. So those issues were not in dispute. There is a dispute about the degree of psychosocial harm, which I'll come to, but it was very severe. The difficulty we have in Australian law is that there is no generally recognised what's called a tort, or you can bring a claim in negligence. There's no generally recognised tort for psychosocial harm suffered because of the way your employment was terminated. So as a general principle, if my employment's terminated, I do not have a general cause of action to go and sue my employer and say, you terminated my employment negligently without proper regard for my well-being and health and safety. I've suffered psychosocial harm and I want damages. So that course of action does not exist in Australian law. And that's actually emphasised. So when you look at the Fair Work Act and you look at the unfair dismissal provisions of the Fair Work Act, and for the legislation nerds out there, Section 392, subsection 4, it specifically excludes psychosocial harm from damages for unfair dismissal if you're in the Fair Work Commission. So there's no cause of action there. There's also no general cause of action for psychosocial harm caused by breach of contract. Now, because there's no tortious claim for unfair dismissal, what has happened historically is that employees have brought claims for breach of contract, and that's what happened in this case. So it's a reasonably complex process whereby you have an employment contract and your employer has a range of policies and procedures that deal with performance management, workplace policies, and those sorts of issues. And what an employee will argue is that those policies and procedures have been incorporated into the employment contract. And if you do not comply with those policies and procedures, that is a breach of contract, and I can sue you for breach of contract. Now, what the current state of the case law, and based on the 1909 decision, says that there is no general proposition that a person is entitled to recover damage for psychosocial harm caused by breach of contract. Your damages are limited to making good the breach of contract. And there are some exceptions to that case. But what happened in the Elijah case was that the relevant policies that the court found were incorporated into the contract required the employer to put all of the allegations relied on to terminate the employee's employment to the employee as part of the termination process. And that didn't happen. The court found, as a matter of fact, that the decision makers in the termination were considering a range of previous conduct and previous behaviour in making the decision to terminate, and that previous conduct and behaviour was never put to the employer and they didn't have an opportunity to respond to that. And the court fundamentally said that in that provision of the contract that all the allegations would be put to the employer, the parties they were not contemplating at the time of entering into the contract that psychosocial harm could result from a breach of the contract, and therefore it could not extend to capture psychosocial harm. Now, there have been other cases, Nikolic, I think is how you pronounce it, a Nikolic decision, where an employee was awarded quite significant damages, multi-million, I think. Now, it might be millions, might be multi, significantly high anyway, damages for breach of contract. But the term that was incorporated into the contract was an obligation to provide a safe workplace. And the employee in that case was bullied and harassed and I think racially vilified. And as a consequence of that, the court said, well, the psychosocial harm arising from that conduct was foreseeable and therefore damages were awarded. Now, a couple of things happened. The upfront legal position that as a general rule, these types of damages are not awardable from breaches of contract or conduct arising from unfair dismissal claims or unfair dismissals. The court also said that the degree of psychosocial harm, and this is on appeal, I should say. So on appeal, the court said that the degree of psychosocial harm was not foreseeable. So the psychosocial harm suffered by the employee in this case was very significant. Major depressive disorders, and Kate will probably be able to talk to that better than I can. And there was a report in the court that said that this degree of reaction to an unfair dismissal was really quite unusual, quite, I think, extraordinary or exceptional were the words used. So that's sort of broadly talking what the legal framework was. No general claim for psychosocial harm caused by unfair dismissal. You have to bring it into a breach of contract. There was a contract term that was found to be breached in terms of not putting allegations to the employer. There was psychosocial harm that was found to have occurred as a consequence of that breach of contract. The court found that that breach of contract couldn't give rise to psychosocial harm within the current frameworks, and in any event, the degree of psychosocial harm was not foreseeable. And so on appeal, notwithstanding the breach of contract and the psychosocial harm caused, damages were not available. What the High Court has been asked to do is to revisit some of these principles and to look at the extent to which, both on the facts of the case, damages for psychosocial harm ought to have been recoverable, and more broadly as a general principle, do we need to revisit some of the older case law which says there is no right to recover, and revisit that legal principle in Australia? So that's currently where we sit. And I think there's a couple of interesting factors. I mean, quite clearly, our understanding of psychosocial harm and its consequences has shifted somewhat since about 1909, but Kate can probably talk more to that than I can. And it will be interesting to see what arguments we can make. So bear in mind, this is a case, the original decision results, Kate might have it in front of you, but the decision in this case predates the psychosocial regulations that exist in most Australian jurisdictions, apart from Victoria. I don't think you've got any yet, Kate.
No.
So it will be interesting to see the extent to which the High Court or future arguments can say, because we now have psychosocial regulations explicitly in work health and safety legislation, whether that in any way changes what the implied terms in employment contracts might be going forward. So that, broadly speaking, that's the structure. From a legal risk management point of view, and we might return to this, but I'll say three things very quickly. One, organisations need to carefully review and check their employment contracts and their employment policies and procedures to understand what may be incorporated into their contracts and what may not, because we charge off over here creating policies and procedures without understanding their contractual effect. The second thing is, obviously, we need to pay close attention to the Elijah decision to understand where the High Court lands on this, so a bit forward-looking. And probably most importantly, from a human perspective, we need to understand better what it means to actually look after people's well-being and what are the strategies for dealing with these types of cases in our workforce. And I should also say, just before I throw to Kate, we are all working in a very messy and complex regulatory framework. So this is a case that is dealing with the consequences of unfair dismissal. That is a different legal framework from your workers' compensation regime, the new powers under the Sex Discrimination Act, the powers of the Australian Human Rights Commission to investigate, and it's different again from potential proceedings under work health and safety legislation. But the things Kate is going to talk about cut across all of those technical jurisdictions. That is, how do we look after our people? The things I talk about are a little bit more mechanistic and structured depending on what jurisdiction you end up with. So on that note, Kate, I'll hand it to you.
Well, I'm not sure about everybody else, but I always find it fantastic listening to Greg in terms of the way he's able to, in quite digestible way, explain the different legal complexities so that we kind of understand some of those guardrails or some of the legal risks and where those processes would then be deemed to be part of the legal process that would follow. When Greg and I were thinking about having a chat online in regards to this situation, and he provided me with the first instance and the appeal judgments, what we thought would be the best thing for me to do would be to read through the first instance to get a feel for what were some of the, it would seem, the kind of known risk factors from a people management perspective. What were some of the flags that were there that on reading it, you can kind of tell that there were some risk flags there. And so that's what I'll now share, because there were some things that, and also really mindful of the challenge that comes from reading what's happened in a really human situation. So I just want to put that out there as well. But in this particular situation, I think there are some risks that we're all going to be really kind of conscious of and that we've felt in times when we're managing situations in the workplace. One that was very clearly documented was the change in behaviour of the employee. And back to Greg's point in regards to, it'll be interesting to see what how the High Court takes a position on now that there is such an evolution in the regulatory framework attached to psychosocial risk. When Greg and I were talking about this, I posit that there is so much now education that is happening within organisations about the first thing that is expected in the management of psychological or psychosocial risk or mental health in the workplace is looking for changes in behaviour of your employees. And that is, I would now say, a fairly standard and expected sense of what we think people who are leading people and managing people should understand. That if there is a very clear change in someone's behaviour and their emotional state and how they're presenting, that is something that should be looked into more, should be understood better. It's not the role of the organisation to then diagnose or to have any sense of what the psychological harm or the psychological process that's unfolding might be. But yes, there is a sense and an expectation that people should be observing that and then taking relevant action to understand what might be driving that. And it does not appear that that has happened in this case. So I think, again, in the context of what the future might look like, the imperativeness of people, to Greg's point, acting on what the education is, that is now much more commonplace in our workplaces, in understanding that changes in behaviour indicate a risk or indicate something that needs to be looked into more, right? An employer needs to understand it more. So that's point one, which was very, very clear in the first instance judgment. The next thing that I thought was really evident was just the degree of emotionality across both parties. You can feel the degree of emotion in the emails that were being exchanged. The judge comments on the level of emotion during witness statements. So I think, again, for those of us in organisations, being mindful that as soon as there is heightened emotion in the way that people are interacting with each other, that again is something that we need to pay attention to. Because as soon as there is heightened emotion, there is higher risk of misperception, misunderstanding, as well as exacerbation of entrenched positions, which in the context of trying to look for resolution on issues, heightened emotion does not bode well in terms of people being able to hear each other and to interact with each other and to understand each other's position. The third thing that I thought was really interesting from reading the first instance judgment, and I noticed that Carolina is here on the call, and I wanted to call out an article that Carolina Dobson posted on LinkedIn and I reshared just recently in regards to the reality of the complexity and heightened risk that comes from interpersonal conflicts. it is absolutely a known thing that as soon as this dynamic begins to exist, particularly I think in this particular situation between a supervisor and the employee, that the level of risk in that situation is absolutely known to elevate the risk in terms of what's likely to happen from a psychological harm perspective. So I really encourage people to read that article, and the term interpersonalized conflict, when people are making judgments of the way each other are engaging with each other, adds to the level of risk because it adds to the likelihood of the level of harm. So again, not all conflict is the same, not all psychosocial risks are the same. But as soon as you begin to quote Carolina and the work that she has shared publicly, which I think was another couple of people did the original research on that, but I think it's really important, again, from an early intervention perspective, no matter if you're a workplace health and safety person or an HR person or an SME, like these are the things we need to be looking out for and not be blinkered to as though that's just what happens with this stuff. Because if that's the type of experience or dynamic that it is evolving, it is absolutely adding to the risk, and therefore intervention and thinking through with appropriate SME advice how to best manage that situation is absolutely going to be advisable. And I think the other thing that really struck me from reading the first instance was and this is probably because it's in an adversarial environment that we're talking about once something goes to court, but I think for those of us who are practitioners, thinking through what are the protective factors in a situation that is coming to you, what is actually some of the stuff that we know protects people to reduce the harm or to reduce the risk of harm, and to really leverage those protective factors. Because in this particular situation, it was really hard to see what the protective factors were for this particular employee. And I think in the contextualization of risk, that also adds to the level of risk and the likelihood of additional harm or exacerbation of harm when somebody doesn't really have stuff that's clearly able to be articulated that is protecting them and their well-being in their workforce, whether it's supportive leadership, whether it's really close collegial relationships, whether it's that they're, that they are mastering and progressing in their career, things that we know help to take the edge off exposure to psychological hazards. There was none of that present that was articulated. So again, on reading it, for me, it felt like a risky situation. And I think then the final one, Greg, that I would probably call out, which I think is a really practical one for us all to think about, and I really wanted to ask you about this, Greg, because I think it connects in with your writing on paper safe and proving safety and the kind of concepts that you are really bringing to the front of mind within the safety sector, is the idea of documentation. And the employee themselves felt that they were sprung with some information that was stated as though it had been talked about, yet the employee did not believe that it had been spoken about or that they hadn't heard it, understood it, whatever the perception of that is or whatever the reality of that is. The employer wasn't able to provide any documentation to substantiate that those conversations had happened. And the employee was saying, well, this is new news to me, that was how I was perceived within this workplace. So, Greg, that's probably a good one to come over to you with your paper safe kind of lens over that in the context of performance management and documentation. Because from a human perspective, if I put my lens over that, there is something quite hurtful when you see something written down on paper that is new news to you, which does go to your competency as a human in an organisation. And I think that how organisations manage that is really a very, very practical something for people to think about in terms of the potential impact on their piece.
So, I'm off mute. Okay. So, there's always a judgment call between, an informal discussion where nothing is recorded a discussion where you as a supervisor or a manager might record the conversation in a private diary or a private file note, but not share it with the worker, a conversation that you share with the worker, but not in a formal sense. So, I'm just confirming this is what we spoke about, this is what we agreed. And then the more formal, here's the formal notice that this is what we spoke about and it's going on your file. And that's always going to be a judgment call for the organisation. But I think as a matter of good practice, organisations need to be very careful, even if the notes are documented, they need to be very careful about relying on those sorts of file notes or conversations or documents when they have never been presented or confirmed with the person.
By the person, yeah,
So
I agree.
I think that's always going to be problematic. And we come across this all the time in these sorts of conversations with employers that, and it's difficult because, this has always been a problem, Greg. We've always been trying to deal with this, but we've never escalated it. And the most difficult cases, of course, are those ones where there's lots and lots and lots of instances to irritating but minor kind of behaviour that doesn't escalate over time, but causes ongoing tension within the organisation over time to the point that it sort of can't be tolerated. So they're always difficult cases. Yeah.
And I think before we kind of open it up a little bit more, Greg, for Q&A, that thing that we were talking about before we actually came online about how it feels to the employee when they are in a process.
Yep.
And almost like the triggering of additional risk, human risk.
Yep.
That happens as soon as a person feels like they are being pushed along a process versus how it feels to the human when they genuinely are feeling as though someone is asking what their perspective is, seeking to understand the contributing factors from their point of view, and also then the organisation then demonstrates back on having heard those things, some changes or some nuance to the next step, because it's mitigating what it is that person is saying that they're experiencing at that moment, or that they are concerned is creating injustice in the organisational justice system, which is obviously the key psychosocial risk that we're talking about in the context of these processes.
In this case in particular, yeah. So it's interesting. So I think for a long time, the historical framework around the management of this has been in a workers' compensation perspective, where the get out of jail free card for the employer is reasonable management action. So we can avoid the consequences of badly or mishandling somebody if we convince a tribunal that it was reasonable management action. I'm not sure, and we don't know yet. Well, sorry, let me go back a step. The reasonable management action defence, it would not be a defence necessarily in a breach of contract claim. So that's a different scenario. And we don't know exactly how the reasonable management idea will play into the reasonably practicable concepts of work health and safety. So that's still got to play its way out. So there's an issue there. But my experience has been to that point of process, if you like, Kate, is most organisations will have a tripwire in their organisation, whether it's a grievance procedure or a complaints policy or something. So an issue has arisen in the organisation, we try to deal with it, but once it goes into a formal grievance procedure, that's kind of like a tripwire. And then we get into this mechanistic process where we've got to follow the bouncing ball to the end, and it becomes very much justice being seen to be done as opposed to any deep exploration of the needs of the parties. I
totally agree with you on that. And I think in all of the situations where I've been involved to try to provide some subject matter expertise about what is most likely to create a better human response.
Yep.
That it has been fascinating to observe an organisation's own values in the sense of, do they go with what their own values are and what the advice might be in regards to what's more likely to get the better human outcome for all parties? Or do they follow what their legal advice is in terms of this is the next step of the process? And I don't think necessarily, well, often those things are totally mutually exclusive, because the next step of the legal process is going to create a higher risk to the human outcome.
Yeah, I think we need to be a little bit careful to distinguish between the legal advice and what the process says.
Right.
So often if a lawyer is telling you this is the next step, it's because that's what you've written in your procedure.
Yep.
I think there is a reasonably strong argument for organisations to when you look at a classic grievance procedure, it says once a formal complaint has been made, you've got X number of days to notify the receipt, you've got X number of days to tell the person, you've got X number of days to appoint an investigator, you've got X number of days, that sort of mechanistic process, and there's no discretion. The procedure says once X happens, A, B, C, D, E, F, G all follow, typically within set timeframes. And I think there is a compelling case, given what the psychosocial legislative framework looks like now, to include a discretion at the start of the process or even throughout the process to say it's not mandatory that we follow the bouncing ball all the way to the end, because grievance procedures are designed to set up to determine a winner and a loser. That's what we end up with in grievance procedures. And I think there's a compelling case to create frameworks for mediation or counselling or case management or something like that, and moving very much away from this linear, investigative, almost quasi-judicial process. And that's a whole separate discussion, but I think there's something around that we need to think about pretty seriously.
And it was interesting to me when you said that the defence has been, from a workers' compensation perspective, anchored in the reasonable management action process argument, because I think what is really interesting when you read, the first instance judgment, and I think a lot of us have been educated on just the extraordinary intellect and capacity to integrate information from looking at the judgment and the way that Justice Lee wrote the Brittany Higgins judgment as well, in terms of the tone matters. Like, the judges do look, from what I'm piecing together, what the tone of communication, what that was like, what the tone and emotion of a witness was like, to help them to try to piece together what the right judgment call is on their decisions.
And look, that's not unique to this. I mean, judges are always any judicial officer is always in the unenviable position of having a party's version of events, then having to observe a witness in the witness box, and at least in part, based on their demeanour in the witness box, determine how likely it is that certain words were spoken in certain ways, or if the way that this person said those words would have caused this reaction. And it's a reasonably artificial environment. And, you can take a set of words on a piece of paper and you can read them, and the way that you read them can be very different in terms of what an expected response might be. So it's always an unenviable position. And that's why, again, if I put my really pure lawyer's hat on, that's why litigation is so risky. You have no idea how you're going to come across in a witness box to another person. So litigation is always a risky option at the best of times. So I notice we've got some questions in the chat. Do you want to leave that on, Kate, and we'll see where it takes us?
It's exactly where I was looking. So there's a question from Blake, which, can you see that one, Greg? So
how do we handle a situation where worker and management disagree on what is a psychosocial hazard? A hypothetical example is given that a worker thinks a newly deployed accounting software is complicated, inefficient. They think it's stressful and it's giving them anxiety, and the manager thinks they're overacting and will get there eventually. What does the courts think about that kind of scenario? I think there's two parts to that. Courts will often, in those scenarios, they probably won't form a view necessarily about the efficacy or otherwise of the software or the process or the change management. They will certainly look at the process to introduce it. So if it's introduced without training or support or anything like that, the court will take that into account.
Yeah. And that comes to the psychosocial risk of change management, will be where that would be considered. Yeah.
The court will look at the person's initial reaction to it. So if the person's initial reaction to it is really unreasonable, straight off the deep end, refusing to come into work without any conversation or discussion, that'll be taken into account. And in the same way that the court will look at the reaction of the employer to the complaint and whether they're proportionate or reasonable and what that ends up looking like. And that, again, that is a complicated scenario to deal with.
And I would suggest in those instances, Greg, that what would be reasonable, I think, would be to make sure that an employer is hearing one person's perspective and then seeking to validate and test more broadly with other people in the team. Because if ultimately the feedback is that the system, and this does happen, hey, you know, systems are put in place and it just does not provide the efficiency that was forecast. That this is where I think that it's so fascinating in terms of how and we've had this discussion a lot in terms of what this psychosocial risk angle will place on business in the sense of what's the reasonable outcome. Like if an organisation has invested all this money in a new software system and it was, you know, deemed to just be a bad decision, right? Like it was just the wrong decision or whatever's happened and it just didn't result in the forecasted benefits. What happens next, right? Like it's unreasonable to think that an organisation would be ordered to remove it. Like could you imagine? Like I can't imagine that could be an outcome, but what happens to the human beings in the meantime?
Look, I think we're decades away from testing all of the boundaries, the outliers, okay, of what this might end up looking like. But to take your point, just to look at it from work health and safety perspective, there's obligations to consult with workers or work groups about hazards. So are we at a stage where it is reasonably foreseeable that the introduction of new processes could create psychosocial hazards for the workforce?
Yes.
And does that mean then if we are introducing new computer processes, rostering, shift changes, staffing levels, reporting lines, all things that we have seen historically, at least in a workers' compensation perspective or stress-related claims, have triggered those sorts of adverse reactions in people? So does that now mean all of that has to be subject to work health and safety type consultation to understand the potential psychosocial risk? Because if the answer to that question, and I think theoretically the answer to that question is probably yes at some level, but what is the practical implications of that? What does that look like? And I'm not sure we have an answer to that yet. We've started to see the fallout of that in relation to COVID. So, you know, we're starting to see some of these cases now about people who had action taken against them in relation to COVID, although that's very much in an industrial relations dispute between union and employer context. We haven't seen, as far as I can tell yet, work health and safety regulators picking up and running with that. I mean, we've certainly seen them. There's been cases where we've dealt with the regulator who has issued improvement notices for organisations who are going through a change process that involves rosters, restructuring and redundancy, where they've issued improvement notices to say you haven't investigated the concerns of your workers as work health and safety matters and you haven't consulted. So we're seeing that. So there's a bit still playing out in this space, and it's a very untidy area in terms of regulation because there are so many overlapping jurisdictions.
And I think just in that whole piece attached to change management and any kind of transformation programs, you know, whatever it might be that's being deployed in organisations, you know, the really purest change management experts would always speak to the importance of pilots and testing and, you know, making sure that a staged approach to get feedback and to understand implications and all those things like that's a key component to best practice change management, that it rarely happens in organisations before big transformation programs are actually deployed. And so, might this be the moment where change experts do get the investment that they're asking for in terms of how to bring about change and how to execute on change, leveraging what we know is best practice? If we can break down the silos in organisations and actually get the safety people and the change people kind of talking to each other to support each other in the business cases attached to those things, which I just don't think we're there yet. I just don't think that kind of breaking down the silos is happening enough to support each other in that broader outcome of trying to get change to be effective and to be deployed effectively and to land effectively and to bring about the change that people are wanting in organisations. So it's an interesting space.
Change and consultation is interesting. The case law is pretty solid that it needs to be genuine, whatever that looks like, and how you evidence genuineness is difficult. It has to be genuine. People have to have a genuine opportunity to provide their input, but it's not a right of veto. And I think the biggest complaint about most change management processes is you've already made the decision, you're just going through the process, and that's hard to overcome. Anyway, there's a heap of questions dropping through. Do you want to pick one?
There was one here from Dominic about the risk to supervisors, which I think is a really interesting one in terms of suggestions to manage or decrease the risk for the supervisor where there is conflict at play. This is so tricky, but so real. And I think it's hard to give a one-stop answer to this, to be honest, in my view. I think those types of situations are ones where bringing in some SME advice in terms of doing a comprehensive kind of understanding of the history of the relationship, what's actually happening at the moment in terms of the key triggers, what started the conflict, because if people have got a really solid history behind them of a really good relationship, some of the times that I've seen relationships deteriorate the most significantly is when people have been friends in those types of relationships, which goes back to the article I was talking about before, when friendships get impacted and deteriorate because of something that's happened at work. The outcome I've very rarely seen those things end well and effectively in the context of maintaining supervisory employee relations. So I would adopt, to be honest, and I know this sounds like I'm probably skirting around answering, but I do think those things are very nuanced. I think they require a careful case-by-case assessment of the history of the relationship, the trigger of the conflict, the degree of emotion and hurt that's currently existing in the conflict to try to navigate a path forward. I certainly don't think that forcing people into mediation is advised. I think that you need a careful assessment around that before you begin to force people to speak to each other. But I do think that some practical things like making sure that there's somebody who both parties think can sit in on conversations so that both parties feel a little bit more protected if they do still need to interact with each other, and maybe trying to get the dynamic to shift a little bit by diluting the intensity of one-on-one contact, and those types of strategies can work quite effectively so that people can rebuild and repair relationships. So that's really what I would describe as quite a complex, often process, but something that needs to be considered and supported and thought through really carefully. One
observation I'd have on that, and I don't have an answer for it, I would be guided by experts like yourself, but one of the unintended consequences of a lot of the language around a victim-centric approach is we are personally seeing more examples of supervisors really both feeling really put out by the process because all of a sudden, hang on, it's all about this person who's complained about me. Excuse me.
About?
There's a story. Yep. There's a story to be told here.
Yep.
Or just not being prepared, particularly younger supervisors, simply not being prepared to be engaged in the process at all, in the sense that they don't take on their supervisory responsibilities for people because they just feel so exposed and so vulnerable. So there's a fair bit of work to be done around this sort of stuff. I mean, the sort of case scenario that keeps me awake at night is when a supervisor gets prosecuted under WHS legislation for not properly exercising their obligations from a psychosocial risk perspective. Now, regardless of the rights and wrongs of that particular instance, that will be interpreted by so many supervisors around the country as saying, whoa, okay, I'm just going to report this up. I'm not dealing with it. And I think we've got some, I'm not saying this is a reason not to deal with the issue, but I think we've got a lot of unintended and quite foreseeable consequences of psychosocial regulation coming at us.
Or for that supervisory layer, I totally agree with you, Greg. And for anybody who does kind of watch what I speak about on LinkedIn, that to me is so foreseeable in terms of what is happening, in terms of the general level of well-being for people in leadership and supervisory positions, and the lack of organisations responding to change the leadership system or to design a leadership system that supports leaders to be who they want to be and who organisations need them to be. There is a significant gap in terms of what's going on in organisations in regards to that at the moment. And to your point, Greg, I think it's going to end up with an organisation saying, well, unfortunately, we've looked into it and the supervisor didn't do what they've been trained to do or that they know that they should have done. And then the supervisor saying, well, hang on a second, you've cut my resources by this amount over the last X amount of years. You set me up for a 60-minute online thing on something to do with this. That's not adequate. That's not a safe system for me. And it's going to end up like that. I think you and I have talked about that before, and we can see that unfolding. Yeah.
I'm going to pull up another quick question because we've only got a few minutes to go.
Yeah.
Anthony Shaw, as an organisation, do we prepare for reasonable management action defence? And this is in the context of workers' comp. I'm not a workers' compensation lawyer, but from what I would say from the outside looking in and my work in employment and safety, I think one of the most important things you can do as an organisation, and this is problematic from everything we've already spoken about today, and so how we work our way through this, what is clearly important is compliance with your own processes. So if you have processes that are set up to deal with the sort of responding to complaints or responding to issues, it's vitally important that you genuinely comply with your own processes and genuinely seek to understand the different people's perspective and manage them appropriately. It seems reasonably clear that any level of non-compliance or any level of sort of mechanistic tick and flick of those kind of management processes will be very problematic in the whole reasonable management action process.
Thank you, Greg. Well, thank you so much to everybody for coming along for our conversation. If you did want to send Greg or I anything, any messages or feedback on LinkedIn, please feel free to do that. Thanks again to everybody, and have a safe and a truly safe, not a paper safe afternoon. Farewell. That's a wrap for another episode of Judgmental. Thanks again to our sponsors, EML. EML's Mutual Benefits Program provides organisations with free services, tools and resources to manage their workplace risk. You can follow EML, myself and Greg on LinkedIn, and be sure to check the show notes for links to the papers referenced in each episode, as well as resources available to help you as you navigate the wonderfully complex and nuanced world of psychosocial risk. See you again next time at the bar.